Good afternoon, and welcome to this session. My name is Albert Lin. I co-chair the appellate practice at Hunt & Andrews Kurth, but I'm also the chair of the Federalism and Separation of Powers Practice Group, and this is our panel, so thank you for attending. I have the privilege and honor to introduce the moderator, who is my former boss and friend, Chief Judge Bill Pryor of the 11th Circuit. Judge Pryor was appointed to the 11th Circuit by George W. Bush in 2004, and he was confirmed by a vote that used to be considered close, 53 to 45. But I think that has been beaten several times over now. He became the Chief Judge of the Circuit in 2020 and continues to serve in that role today. Judge Pryor, before he was appointed, was the 45th Attorney General of the great state of Alabama, a role that he served in from 1997 to 2004. Before that, he was, among other things, a law clerk to Judge John Minor Wisdom from 1987 to 1988. He is a graduate of Tulane Law School, where he finished first in the common law curriculum and was editor-in-chief of the Tulane Law Review. I could go on for a while about him, a person who I greatly admire, but let's get to the panel. So without further ado, over to you, Judge Pryor.
Thank you. Albert Lin was the first of my law clerks ever to clerk at 1 First Street. He paved the way for a lot of folks. Our panel today is a really interesting one, and as usual, the Federalist Society has assembled a great set of speakers. It's a hot topic. In recent years, leaders of both parties have invoked emergency powers to address issues from the COVID-19 pandemic, immigration and drug trafficking, trade deficits, and more. President Trump has faced legal challenges to his executive orders and emergency powers in the form of universal injunctions and temporary restraining orders. In Trump versus CASA, the Supreme Court held this year under the Judiciary Act of 1789 that it is beyond the scope of the judicial power for federal courts to issue universal injunctions. Now, some argue that courts should defer to executive assertions of emergency powers. Others contend that courts should engage in strong judicial review to forestall threats to civil liberties and the separation of powers. This panel will discuss the scope of judicial power, conflict between the executive and judicial branches, and the broader impact of CASA on federalism and individual rights. I'm going to go ahead and just briefly refer to each of our panelists. If you haven't already done so, you should download the convention app so that you can see the full biographies of all the speakers. So I'm going to give abbreviated introductions so that they have more time to talk about our topic. We will begin this afternoon with Professor Garrett West. Professor West is an associate professor of law at the Yale Law School. He will set the stage for us and might have a little more running room in terms of time as he does so for the panel. He will then be followed by Chad Mizell, who is, as of very recently, now the former Chief of Staff and Acting Associate Attorney General at the Department of Justice. Chad will then be followed third by Professor Interim Dean Merritt McAllister, who's the Interim Dean at the University of Florida Law School. Merritt will then be followed by Ted Frank, the co-founder and director of litigation at the Hamilton Legal Law Institute. And then wrapping it up for the panel will be Stephen Spalding, who is the managing director of the Kohlberg Center at the Brennan Center for justice. So please join me in giving a warm welcome for our panel. And we'll begin with Professor West.
All right, thanks, Judge. So during the maybe 10 or 15 years or so in which universal injunctions were becoming increasingly common in the courts, there were maybe two arguments that people offered for why they were bad. The first was like a formalist argument that judges are just not allowed to give relief to non-parties. And so it's exceeding either Article 3 or maybe the Judiciary Act of 1789 to issue injunctive relief for non-parties who aren't directly before the court. The second set of arguments was related, but it was really a functional argument that practically these are really bad for the world. And the reason they're bad is because they incentivize forum shopping, they let a single plaintiff's victory block an entire executive branch policy, and they also sort of forced, rushed high-stakes litigation up to the Supreme Court's emergency docket or interim docket or shadow docket or whatever we're calling it docket. So there was the formalist argument and the functionalist argument, and the good news about it is that the CASA opinion from Justice Barrett is a brilliant vindication of the formalist argument that says universal injunctions are totally impermissible. The bad news is that it practically will make almost no difference with respect to the functional problems created by the universal injunction. And the reason it will make probably no difference at all or hardly any difference at all is because there are so many alternative mechanisms for plaintiffs who are motivated to get something like a universal injunction to go get one. So what are the main alternatives? One, class actions. Class members, if there are enough of the members, they can ask for complete relief from a particular court, and the injunction might be basically just as broad as it would have been if it had been a universal injunction. Second, there's associational standing. So nonprofits can bring claims on behalf of their members, asserting injuries to their members. And if they have enough members, it might be broad enough that the injunction is effectively a universal injunction. The third category is claims by state governments. So a lot of these state standing cases where the states have sued usually the federal government, they allege some kind of financial injury. And usually it looks like most of the time they can come up with a theory for why it's the case that the court has to completely enjoin the policy to give complete relief to the states. And then the fourth workaround is the APA. And so everybody thinks, or most people think, traditionally, that the set-aside remedy or the vacatur remedy under the APA is effectively a form of universal relief. So at least in the set of cases where there's a challenge to agency action, you can still kind of get something that looks exactly like universal relief. So there are all these workarounds that make it so that the universal injunction opinion is unlikely to make very much of a difference. And it's also the case that plaintiffs are highly motivated to seek universal injunctions because the people who are litigating against, say, the executive branch are usually doing it for ideological reasons and because they want to block executive branch policies. And it's also the case that the plaintiff gets to sue in whatever district court the plaintiff wants. And so the decisions are systematically likely to be ones that favor the challenges to government policies. So all of the problems that led people to be concerned about universal injunction are probably going to continue in the near term at the very least. What can you do about it? If you think it's a problem, what sorts of things can you do about it? So I'll just quickly propose maybe two possible sets of solutions that you could have if you think that it's a problem that district courts are largely controlling major executive branch policies in both administrations and also a lot of major state policies. So one set of things you could do is you could just radically disempower the district courts to do the various things that let them give effectively universal injunctions. So you can get rid of associational standing, and you can get rid of state standing, and you can get rid of APA vacatur claims, and you can also get rid of class actions. And, you know, a lot of people think maybe that's not plausible, either because it doesn't seem like a good idea to not let states sue or let class action sue, and also because you would have to kind of do all of those reforms if it's going to work. Because the whole idea is that they're substitutes for each other, and the plaintiffs are smart and they're engaging in forum shopping. And so if any of the alternative mechanisms to get something that's like a universal injunction is still available, then the plaintiffs are going to find it and seek it out and get it. So a second set of possibilities is that we can just kind of accept that maybe this is kind of how the courts operate now. Maybe they just kind of determine whether or not executive branch policy is illegal or legal in a kind of up or down vote, like a council of revision that we weren't supposed to have at the founding, but maybe we effectively do have now, and maybe we're kind of stuck with it. And if that's what you thought was going on with the district courts, then what you might think is that you need to try to centralize that activity, centralize the ability of courts to say up or down whether or not the executive branch or a state is engaging in lawful activity. And so what would centralizing look like? Well, there are lots of options. My personal favorite is a presumptive stay of district court opinions in the category of cases where it looks like they're enjoining major nationwide policy. And a presumptive stay could be adopted doctrinally by courts of appeals. It might be adopted by local rules for circuit courts. Some of the circuit courts currently have policies where they issue presumptive administrative stays in immigration cases. And courts of appeals could do that too. Congress could do it, but I won't dwell on that because, and then maybe the federal rules could be amended to change to amend, Federal Rule of Appellate Procedure 8 to permit one of a presumptive stay of a district court injunction or other form of prospective relief in a case where they're effectively blocking major executive branch or state policies. Some other more far-fetched possibilities, and then I'll stop talking about it, are one, a lot of these cases are going to the Supreme Court, and maybe we should just accept that they should go to the Supreme Court sooner and easier. And one possibility would be to try to transfer cases from the federal district courts to the Supreme Court's original jurisdiction. Actually, some of the Voting Rights Act cases in the 60s were resolved in the court's original jurisdiction. A third possibility that I like a lot too, but it would also require Congress to do something about it, so maybe it's a little too far-fetched, is you could have a kind of centralized court that's drawn from judges throughout the country, either selected randomly or maybe selected by the Supreme Court or the justices of the Supreme Court. Say 30 judges that are responsible for deciding the kinds of cases that we're talking about where plaintiffs want major, effectively universal relief against an executive branch policy. And those judges could resolve these challenges in 3-judge panels, maybe with 1 district court and 2 courts of appeals judges, or 2 district courts and 1 court of appeals judge. And the appeal could be directly to the Supreme Court rather than up through the Court of Appeals. So I'll close by just suggesting the universal injunction thing that's been going on for a while was a bit of a problem. I don't know that it's going to be possible to embrace the series of reforms that would be necessary to eliminate the availability of universal relief in the district courts. So it might be worth thinking creatively about alternative mechanisms to centralize adjudication and to get them out of district courts that were selected by the plaintiffs and into into the courts of appeals or to sets of judges that were not selected because they favor the plaintiff. Thanks.
Chad.
Judge, thank you very much. On this issue, I want to pick up right where Garrett left off. I would say that this is actually not a problem of structure, but rather a problem of politics. And specifically, I'm going to make the argument that this is a problem of leftist politics. This is not a both sides problem, though that's something you're going to hear a lot, and I think you'll even hear it up here. This is fundamentally a Democrat-appointed judge problem. And I think if you look at the facts of this and some of the specific examples we've seen over the last 9 months, 10 months of the Trump administration, it proves this out pretty clearly. So let me submit these facts to this candid world. Bush had 6 injunctions against him. Half of those were issued by Democrat-appointed judges. Obama had 12 nationwide injunctions issued against his administration. 60% of those were issued by Republican-appointed judges. In the first Trump term, he had 64 injunctions. That compares with Biden's 14. And then before the CASA decision, we have a rough count of about 40 issued in the first 6 months of the Trump administration. So over 100 injunctions issued by against the Trump administration. Over 90% of those were issued by Democrat-appointed judges. That means that since 1963, over 3/4 of the nationwide injunctions have been issued against President Trump, with over 90% of those coming from Democrat-appointed judges. Well, some might argue that's just because Trump is more lawless. Well, again, let's look at the facts. 24 emergency petitions were filed at the Supreme Court by the Trump administration this year. They won 22 of them. That's a 92% win rate at the United States Supreme Court. There's not a single other entity, thank you, that comes anywhere close to that. What about Biden administration? During their 4 years, they filed 22 emergency petitions with the Supreme Court. How many did they win of those? 11. A 50% win rate. Well, Chad, anybody can skew the facts. Why don't you give me some specific examples? More than happy to. Let's look at the National Association of Diversity Officers versus Trump. There, the district court enjoined 2 executive orders that instructed agencies to end illegal DEI programs on the ground that they were void for vagueness, because I guess we don't know what the word illegal means. He made the injunction applicable to named defendants and, quote, other federal executive branch agencies who are not named defendants. So he purported to enjoin non-defendants from taking actions against non-plaintiffs. That one we didn't even have to get up to the Supreme Court because the unanimous Fourth Circuit, which is not a particularly friendly place for us, flipped them. What about Nome v. National TPS? There, the statute expressly said, with respect to the temporary protected status designation, there's no judicial review of any determination of the secretary with respect to the designation, termination, or extension of TPS, temporary protected status. Of course, what did the judge do there? Issue an injunction. But it gets even better. That injunction was stayed by the Supreme Court. Well, the district court then goes in and enters a final order granting plaintiffs another injunction and refused to stay it. And the reason that the judge gave was because, quote, SCOTUS did not provide specific analysis on the merits. You can imagine what the Supreme Court did when the case came back to them. What about Judge Tolwani in the Planned Parenthood case, where Congress decided not to fund Planned Parenthood, and she found that it was an unlawful bill of attainder? There again, CA1 flipped. There was another Tolwani case, this one's probably my favorite, where the INA permits parole on a case-by-case basis. That's expressly what the statute says, case by case. Well, Mayorkas granted parole to 500,000 individuals from 4 countries on a categorical basis. Secretary Nome attempted to rescind that determination, and Judge Tolwani stopped her on the ground that a rescission needed to be done on a case-by-case basis. We won that one at SCOTUS as well. Finally, you have the NIH grants case. And I'm only limiting my examples because of time, not because of opportunities here. Judge Young issued an injunction reversing grant terminations under the APA when the Supreme Court had just ruled in a case involving the Department of Education grants that those kind of claims needed to go to the Court of Federal Claims under the Tucker Act. I mean, that actually provoked Gorsuch and Kavanaugh expressly saying lower court judges are free to disagree with our rulings, but they may not define them. What are some of the tactics we've seen used by judges? How about successive 14-day TROs? How about contempt traps? How about leaks? Not only the Dobb opinion, but the unprecedented dozen district court judges talking to NBC News complaining about the Supreme Court. And then what about some of the rhetoric used? Just look at Justice Jackson, who said that the government, in seeking a say, sought to, quote, inflict maximum pre-decision damage. Or in another case where she said, we once again are using our equitable powers to allow this administration to disrupt as many lives as possible. This is the kind of rhetoric. I'm going to end with this story. How do we solve it? We solve it with power. Well, what does power look like? Growing up, we had a stray cat in our yard once. My father called the Humane Society and said, hey, listen, I've got this stray cat. And they said, sir, I'm really sorry. We're on a backlog. It's going to take us at least, 3 months to be able to, send somebody out there and capture the cat. My dad didn't yell. He didn't scream. He didn't ask to talk to a manager. He didn't sue. He just said very calmly, he said, ma'am, I think you misunderstand. I'm from Mississippi. We know how to deal with stray cats. I just wanted to give you a heads up. Within 30 minutes, somebody was there catching the cat. What does power look like? What do I think DJT should do? He should stand up, and he's already done this, and say, judges, I know how to deal with stray cats. Thank you very much.
Dean McAllister.
Thank you, Judge. It's an honor to be here. I'm not going to, I don't think I'm going to pick up the stray cat analogy exactly. But I want to, I think, partly there's a reality here that as long as judges are willing to issue universal relief, and as long as litigants are motivated to seek it, and I think those are going to be present. both sides, both administrations have used executive power in ways that lead to litigation. And as any good litigant, and I spent about a decade practicing law, will be motivated to get the most relief possible for his or her client. So I think there's a way in which this issue is a persistent one that we need to confront. And in that way, I very much agree with Garrett that the CASA decision will not solve this problem if you are concerned with either the scope of relief that's being given or the functionalist problems that remain. I agree the formalist objections to universal injunctions were nicely resolved in the CASA decision, but there's going to be a continued need for at least prompt judicial review of executive action, and that both sides will continue to push these issues. Judicial review may not be the most desirable way to deal with this. Maybe in an ideal world, we'd have Congress would provide more guardrails and clarity. But I think for now, at least in the absence of those kinds of legislative checks, we're going to continue to see lawsuits. And if that executive overreach is part of the constant that we see in terms of both parties. And the question is, what's the path to review? And CASA closes one of those doors, but I think other doors remain. The four doors that Garrett indicated, I completely agree that. Litigants will continue to use those, and we've seen that in the post-CASA world. The sort of what's most attractive to me among the doors that remain would be class actions as a vehicle for raising challenges procedurally that have greater procedural protections, paths to prompt judicial review through the appellate process, but not the kind of, I think, rightfully sort of concerning lawless guardrails on a single district court judge issuing relief without greater procedural protections. So if you think about this doesn't solve, if your objection is with a single district court judge issuing very broad relief to litigants in a nationwide fashion, then you're also going to probably have a problem with a nationwide class, right? And nationwide class relief. So if that's the concern, then class action does not solve that concern. And I think, Garrett's proposed some ways to think about changes that would get at least this problem out of the single district court judge's hands. But what a class action mechanism, and this would be under like Rule 23b2, allows for is greater procedural barriers and hurdles that would protect the process more than having a single individual plaintiff, whether it's a state or an associational organization. I have concerns about expanding standing in a way that states and or associations will try to use to obtain this relief. So my view is that the class action mechanism, at least as a proceduralist, has recognized guardrails that do provide more protection than what we've seen sort of in the pre-CASA world. So a Rule 23b2 class would be available in cases like the CASA case itself. In fact, right after the CASA decision, a New Hampshire district court certified a class challenging birthright citizenship. In public interest litigation, a class action under 23b2 is a viable mechanism if what's being challenged is a single policy that applies across the board in an undifferentiated way to a large group of folks. That is made for 23b2 resolution. It's something that would survive, at least in theory, the present law under like Walmart v. Dukes. It doesn't have a commonality problem if the question is just this single piece of legislation or executive action that applies in an undifferentiated way to a large group of individuals. That can, the lawfulness of that application, if it doesn't depend on any sort of individual circumstances of a class member, could in theory be resolved in one fell swoop, such that a class action mechanism would be the appropriate mechanism for resolving and obtaining injunctive relief under 23b2. Now, that doesn't, I think, I still have pragmatic concerns about this. So think about the value of percolation or the value of getting a judge at a higher court, whether 11th Circuit, 5th Circuit, whatever court it is that has a broader jurisdiction to resolve these issues and weigh in before something reaches the Supreme Court. In theory, under present class action law, unless it changes, you wouldn't have to have multiple litigations. You could have a single nationwide class that is certified, that provides the same kind of relief that was sort of pre-CASA relief to an individual plaintiff. There would still be procedural protections in terms of an immediate appeal. So just like a preliminary injunction is immediately appealable, a class certification decision is also appealable. That would get you very quickly to a court of appeals, and the similar stay mechanisms or relief in the Supreme Court and the shadow docket. So you still have an appeal mechanism that's immediate. The class process is certainly more rigorous than, at least as a procedural mechanism, than what we've seen before now. So in that way, it's sort of an appealing middle ground to me. I think that we're going to see some pressure on what current class action doctrine looks like. If your objection is to the ability of the district court to just issue relief that's this broad and that has nationwide effect, then I think that puts pressure on changing some of the existing class action doctrine. But I do think that would require a change. That under current law, under Walmart and post Walmart v. Dukes public interest litigation, the problems that have arisen are not with challenges to official policy that applies across the board, but to institutional reform cases where they might depend more on how a law applies to the individual circumstance of, a set of plaintiffs or a subset of the class. So a properly defined class, and that's a big if because it would have to be properly defined, but a properly defined class, I think, is a route to obtaining the same kinds of relief that you see in CASA. And my view is that will probably be the next big bucket where litigation moves, and will require some deeper thought about whether that's ideal. Do we want district courts giving nationwide relief for a nationwide class? Current law would allow it, but I think that that question will be one of the next one that gets teed up before the Supreme Court.
Okay. All right, Ted.
Thank you. My cardiologist said to stay away from stray cats, so I'm going to focus on Justice Alito's concurrence in CASA, where he acknowledged the appropriateness of class actions as the device for providing universal relief, but suggested that it would be important for courts to apply the rigor that is demanded for class certification. And how has that played out? The answer is, in the 4 months since CASA, there has not been a single court that has denied class certification when deciding to issue universal relief. They've certified the class. Even the Supreme Court itself in AARP, sua sponte, certified a class in effect in issuing its order. So what can the government do in response to this? Is this a real, are these real guardrails, or can the government sort of create guardrails that aren't there right now? And one avenue, I think, is in the 23A requirements for class certification. These have generally been very, very loose. But if we are to believe that a class representative is supposed to be the adequate representative of the class, rather than just the cat's paw of the attorney, there is room there for litigation over what 23A4 means and whether the handpicked plaintiffs of the public interest litigators are appropriate class representatives. more promising, I think, for the government, given where the Supreme Court has sort of suggested things might lie in cases like TransUnion versus Ramirez, is the question of standing, Article 3 standing on a class-wide basis. There is a tremendous fractured split among the lower courts of appeals on this question, ranging from it's just the class representative that needs to demonstrate standing to everybody needs to demonstrate standing, and then every conceivable interim step in between, there's a court of appeals that's adopted that rule. In LabCorp v. Davis, the Supreme Court granted cert and then ultimately decided that even though they were reviewing the Ninth Circuit, cert was improvidently granted. But a statement by Kavanaugh suggests that the Supreme Court is looking very closely at this issue. I think one other development, not necessarily on our question, but what are going to be the repercussions for class action law now that class action law is so heavily tied into this public interest impact litigation that's getting decided very quickly by district court judges acting under duress, and then onto the Supreme Court emergency docket. I think we could see some pressures in what is going to become an even more politicized area of civil procedure.
Okay.
Thank you.
Thank you. Well under his time.
Well, it is great to be here. Thank you, Judge, and thank you for inviting me today. I'm going to focus my comments on the part of the panel title that talks about, quote, judicial oversight of district courts, and more specifically, how the Supreme Court is using the emergency docket or the shadow docket or the increasingly en vogue interim docket to second guess the judgment of lower courts. And what I'm talking about is the growing set of emergency orders, summary rulings issued outside of the ordinary merits process, without full briefing, without oral argument or signed opinions. Of course, a notable exception being CASA, where the court, it came to the court by way of the emergency docket, but where the court ordered argument and, of course, did issue a lengthy explanation for its decision. Of course, historically, cases on the emergency docket were a narrow part of the court's work reserved for true emergencies, think capital cases. But its reliance on it has expanded dramatically recently, particularly under the current administration. Some statistics. In the first 20 weeks of this year, the second Trump administration made 19 emergency docket applications, which was the total that the Biden administration made over 4 years. This is according to statistics by Professor Vladeck. The Obama and George W. Bush administrations combined made 8 requests over 16 years between 2001 and 2017. So there's a decent case to be made that the court's use of the shadow docket to address these significant legal issues and foreshadow the overruling of longstanding precedent, Humphrey's executor, et cetera, without offering so much as an explanation, can unsettle the law and put the court in an unfavorable light, because the court's power comes in part from the perception that its opinions are reasoned and transparent. So without the benefit of the usual merits docket, with full briefing, as I mentioned, with oral argument, with lower courts being given time to establish the facts, develop a record, the court does feed a perception that its rulings are based on particular ideologies rather than judicial principles. That can feed that perception by not issuing fully reasoned opinions in its decisions. And because these decisions are often, as I said, provided with minimal explanation, lower courts are left guessing as to what precedential value these decisions have, as the court and its justices have sent mixed signals on this. And so the shift does have real implications for the role of district courts. District judges are the first line of review. They're developing the records, applying the law, issuing injunctions to preserve the status quo while cases proceed. And what we've seen so far this year is it has issued 22 decisions on the emergency docket concerning administration policies. 19 ruled for the administration, at least partially. 3 ruled against the administration, and 7 were not accompanied by any explanation at all, and others with as little as a sentence. And so it can send a signal that the court is more concerned with district court judges than potential overreach by the executive. So as we've heard about, we've already seen judges talk about this earlier this fall when a judge talked to NBC News about how, quote, judges in the trenches need and deserve well-reasoned, bright line guidance. Too often today, sweeping rulings arrive with breathtaking speed, with minimal explanation, stripped of the rigor that full briefing and argument provide. So as I close, I'll just say that it is worth recognizing that this trend is not happening in a vacuum. The court is operating under new pressures. Presidential assertiveness has pushed the court to act earlier and earlier in the life of the case, often with the limited record. But what we are seeing is a pattern of executive action, lower court injunctions, and an emergency docket that is straining under the weight of decisions that I think would be better dealt with on the merits calendar, and eventually will be, but could be dealt with on the merits calendar. And I don't think the court has yet figured out a way to manage that tension. And that's because there are genuine pressures. People have put forward various paths forward: earlier merits argument, cert before judgment, structured expedited review that could preserve and encourage deliberation. So I don't think reforms in this space would handcuff the court. I do think, though, that insisting where possible on a reason, on a reasoned explanation, on an opinion, however concise, with standards that are clear and consistent, would help, because that's what courts do. They are supposed to explain themselves. Thanks so much.
Okay. Thank you. So before we open it up to others, I wanted to give Professor West an opportunity to react to what some of the other suggestions for reforms were, or responses to his.
Oh. Yeah, so this could be the part where I just say why everybody's wrong, and then we can argue about it. That might be more fun. I'll just go in order. So, Steve, I thought you were going to say that the shadow docket is really bad because they're not explaining themselves, but then at the end it sounded like you said the shadow docket is kind of fine and we should just make it slightly better. If that's the argument, then I kind of agree with it. I mean, the reason the shadow docket is what it is because of what I was talking about with the universal injunctions. The court thinks that it should be resolving really important national policies, and it shouldn't be resolved by the District of Maryland or the District of Hawaii or even the Northern District of Texas or whatever. Like, major national policies should be resolved by democratic elections, or if it has to be through judicial review, it probably should be through the Supreme Court. So the Supreme Court, when it gets these petitions, like, it's got to rule on them, and it can't just leave it in the lower courts over the period of time. So I do think you kind of just have to embrace and try to make it better. And it sounds like that's what you were suggesting. Like, they should act more quickly and grant cert before judgment. They should argue it earlier, and then maybe they could write shorter opinions. But I think that's just accepting that the interim docket or the emergency docket is just like part of the new normal for judicial review. On the class action stuff, I mean, the class action guardrails are not going to work. And the reason the class action guardrails won't work is, one, what Tad said is they're not working. They so far are not working. Two, I've read like multiple papers already from people who supported the universal injunction before CASA, who've argued, basically, don't worry, if you interpret Rule 23 appropriately, you can still get a universal injunction in every single case that you would want to. And it's also the case that the judges that are going to be deciding whether or not Rule 23 has been satisfied are still going to be selected by the plaintiff. So, of course, they're going to say, oh, yeah, we think that there's a subclass here and it's legit and we should have a universal injunction. An injunction for the putative class. And even if it were the case that the Rule 23 limitation guardrails would work, it wouldn't matter because Rule 23 is just one of the mechanisms by which you can get something like universal relief. So if the plaintiffs are smart and they think they're going to lose on a Rule 23 motion, they'll just get an association, or they'll talk to a state Solicitor General's office and have them sue. And because there are all these other alternative mechanisms, unless you can shut down every single one of them, you can't shut down any of them. So you really do have to make like structural changes and to maybe even embrace something more like the shadow docket. The last thing is on Chad, on the idea, even if you think that, I think many people in the room think that there's an asymmetric problem with respect to who's stopping whom. Who's the bad actor here? Is it the Republicans or the Democrats? Even if you think it's an asymmetric problem, you might actually still want to do one of the structural solutions that I'm talking about, because the judges are who the judges are, and the incentives of the plaintiffs are what the incentives of the plaintiffs are. And so if you don't take steps that deal with the structural incentives of the parties and the structural reasons for stuff like universal relief and the pressures on the shadow docket, then you're not going to be able to solve the problem, even if it's an asymmetric one.
So, any reactions?
I'll just, can I just, oh,
Go,
sorry.
go for it.
Just to jump in quickly. I mean, I think it's a bit of a both and. One, I do think the court should explain itself. And I think Justice Kagan put it well over the summer. She suggested that, we don't need to write a magnum opus, but, a few pages of why the court is deciding the case in the way it is would be helpful. At the same time, yes, the court is facing new pressures on the emergency docket. I would question, though, like some of the pending cases right now. One case is about whether the president lawfully or unlawfully removed the head of the Copyright Office. Like, is that a true emergency? We'll see how the court deals with that, or efforts to dismantle the Department of Education. Is that such an emergency that we need to upend the status quo while litigation proceeds? And so I do think there are genuine pressures, so as I mentioned, to figure this out.
I'm just going to add that, is there any value that we see in having the cases sort of go through every level and the sort of the thorough review that comes from a more careful process? We're always balancing here the sort of speed of trying not to let a district court overreach, interfere with executive priorities for in an unnecessary way for too long. But on the other hand, more shortcuts or more emphasis on the emergency docket, faster Supreme Court review does lose something of the percolation of the sort of deliberative process gets short-circuited, especially if then you couple it with a curtailed emergency docket. I don't know. I tend to be sympathetic to this. Like, let's get a new court with 30 randomly sort of selected judges who might sit in panels in different ways. I don't think it's going to happen, but I like that.
If anybody wants to do it, come talk to me.
I jump in on this and say that I think first off, I fundamentally disagree with Stephen that what these, well-meaning, well-intentioned, by golly, we're just doing our level best district court judges are trying to do. Judge Young is a great example of that. The Supreme Court made very clear that grant termination cases belong in the Court of Federal Claims. Nonetheless, Judge Young issued an injunction there and actually sparked a rebuke from Gorsuch and Kavanaugh saying you're not allowed to defy us, right? That is not an example where he didn't know what was going on. How about in the numerous removal cases? I've counted 4 thus far where Trump has removed a head of the agency and the Supreme Court has had to weigh in every single time telling district court judges you're not allowed to reinstate executive heads of federal agencies. Stop it. Cut it out, guys. They're continuing to do this. So I just don't buy that we're living in a world where there's a bunch of district court judges who are trying to actively engage in good faith here. I do very much agree with Garrett that a solution is needed and some of the reforms are needed. I guess, Garrett, where I see myself as picking up where you left off is, okay, here's a menu of options. Somebody please pick it. And I say, okay, well, what's that forcing mechanism? And this is why I like my stray cat example. All right. What is going to actually force the Supreme Court to do something? Well, what's going to force the Supreme Court to do something is fundamentally political pressure. It's going to be when Congress starts impeaching judges and saying you are now stepping on the legislative power. This is no longer a disagreement about how a particular statute should be interpreted. You are now encroaching into our territory, and that is something that even Alexander Hamilton, the Federalist, recognized is a legitimate grounds for impeachment. And I think that is the type of thing in action that is going to spark some of the very reforms, Garrett, that you're laying out.
Okay. Go ahead.
I mean, one problem is it's hard for the Supreme Court acting alone to actually solve the problem. And the reason is if there's a kind of whack-a-mole problem with the universal injunctions. Oh, now it's class actions. Now it's state standing. Now it's associational standing. Now it's the APA. It takes them a long time to do stuff. And it's hard to resolve all of those problems when they have to do it seriatim. I mean, like the universal injunction issue has been kicking around since like Trump versus Hawaii. And it took them until CASA to resolve the issue. So it's just hard to imagine that the Supreme Court acting alone is going to be able to do that much about it. I mean, one thing they could do is they could issue an opinion that says district courts should presumptively stay their injunctions if they block a major executive branch policy, period. Presumptively stay it until the Court of Appeals reviews it.
One of the things you haven't really spoken as much about in terms of universal injunctions and potential reforms is what happens when the state government as litigant is the defendant as opposed to the plaintiff. There's There's a lot of talk on this panel about national class actions, universal injunctions for national relief, but we have 50 state governments. Without discussing, I don't want to talk about any of the particular cases that have come before my court over the last several years, but Florida's in our circuit, and Governor DeSantis and his administration have had lots of policies challenged in the courts of our circuit. Lots of universal injunctions. Do you just have less of a concern about those, Professor West?
Actually, I would treat them the same. I would say any injunction, if I get to wave a magic wand and deal with it the way I want to, I would say any time when there's some kind of prospective relief against either the United States or its officials, or a state government or its officials, that precludes application of a new statute or policy in all circumstances, those cases are ones in which you want to switch the default rule so that district courts aren't the ones who are responsible for making the determination in the first instance. At least you would want the Court of Appeals to resolve it. And, if it's national policy, maybe you would think even the Supreme Court should be the one to determine. And then maybe if it's a state policy, you think the Court of Appeals might be the one because they're, closer to the state or something.
But do you have fewer concerns about a statewide class action that might restrict a state executive or legislative priority?
I mean, the state issues are, I think, just definitionally going to be lower salience than the national one. So if the problem is something like district courts are making major policy for the United States, then the national policy ones are, just, I think, more. But the state ones are still a problem, and I think there's been an increase in injunctions against state policies at the same time that there's been an increase in the number of
let's say there's a class action filed in the Northern District of Florida, can that relief only extend to the Northern District of Florida? On a class action, like if it were a class, would that be the preferable? What would the limiting principle be?
I would just make sure that the Court of Appeals is the one who's determining whether or not if it's a class action and it's against the state, I would say even if they enter an injunction, it should be automatically stayed until the Court of Appeals can rule on the motion for a stay pending appeal. And that would just switch the default rule in class actions. By the way, one benefit of switching the default rule for class actions, associational claims, state claims, is that plaintiffs that really need relief now, really, not just fake I need relief now, can file individual lawsuits and get individually tailored relief without going through the Court of Appeals before they can get the injunction.
So one question I had for you, Chad, is insofar as you describe this as a politics problem, it's not exactly right to say that this has been a peculiar problem to the Trump administration. I think about Murthy versus Missouri, the social media case, no standing, the abortion pill litigation during the Biden administration, some of the immigration cases where there were a lot of, some would argue there was some forum shopping going on with suits that just keep getting filed in Texas, and they didn't fare all that well at the Supreme Court. The abortion pill case was 9-0, but the current administration has been more aggressive, had more executive orders, and as a result, gets more of that kind of litigation. Is that a fair statement of at least part of what's going on?
And so I guess to just repackage the argument, the Trump administration is doing so much so quickly that the number of injunctions is totally unsurprising. I think that could explain part of it. I really do. And you're right. And I didn't mean to say, and nor do I think I did say that it is exclusively a problem, asymmetrically only by Democrat appointed judges. But I said it is primarily a problem because I think that is where the bulk of the issues are coming out. And I think particularly too about some of those cases, the immigration cases, the mifepristone case, even the student loan cases that came out. And there were some standing problems that ultimately Supreme Court rightfully recognized. But I think even in those cases, they lack some of the tactics that we're seeing today, successive 14-day TROs. And then as soon as a TRO is decided to be actually an appealable injunction, we started getting these district court administrative stays, like whatever the hell that is, just kind of made up out of nowhere. Basically just, I want to be able to issue an injunction and I don't want you to go up to my bosses and do something about it. We started seeing these contempt traps genuinely left and right, pay out money in a period of time that is literally impossible to pay out money. Given just how the federal government works, or pay out appropriations that you simply don't have, or bring somebody back from a foreign jurisdiction where you don't actually have any control. So I think that it's beyond just the injunctions. I think that if you actually look at some of the color around some of the injunctions as well, you see that what the judges are doing does feel to me to be fundamentally different. And so even if you could explain the number, based on the number of executive orders and the number of actions, I don't think you can explain some of the tactics around how these cases have been litigated. I used to be able to set my watch every Friday at 4:00 for the first 4 months of the administration. We got a TRO. And a good portion of those were completely unbriefed, by the way. Actually going to a point that Stephen said about, these district court judges just want full briefing. They want full briefing from the plaintiffs. They never wanted full briefing from the federal government. We had a number of TROs where we had a lawyer with 2 hours notice get to show up and try to argue a case and have a 14-day TRO issued against us.
Reactions?
I do want to step back to an earlier discussion and just talk about the shadow docket discourse, which reminds me of that statistical image of a World War II plane and where the red dots showing where damaged planes had where damaged planes had landed had been damaged. And there weren't any dots over the engine. It wasn't because the engine was so impervious. It was that the planes that were getting shot in the engines weren't making it back at all. And when the administration is 19-3 on the shadow docket for the emergencies that they bring, I don't think it's because the Supreme Court is is putting the thumb on the scale in favor of the Trump administration versus what district court judges abuse. I think the administration is doing a very good job of selecting when to go to the Supreme Court with an emergency appeal. And you can hear that from the number of injunctions that have issued, which is much larger than the 22 cases that the administration has taken to the emergency docket. And certainly plaintiffs have been able to go to the emergency docket, most notably in AARP, and get relief from the Supreme Court. So I would caution against sort of suggesting that we can deduce a lot from the win-loss record necessarily.
Okay. I think it's a good time for us to open it up to questions from the audience. The only admonition I have is the one I always have, which is you're not a panelist. We do invite good questions, and you can set the question up, but you're not a panelist. So please make sure you have a question so we can hear several of them. So we have a microphone, and we'll start with you. Please identify yourself, too, before you ask the question.
Sure. Michael O'Connor. Having done civil defense litigation for years, I know that when properly applied, the class action standards can actually be quite rigorous. The panelist has talked a lot about it being an exception to the universal injunction. And I think in one of the cases, the Supreme Court even said you can issue relief to a prospective class or a putative class. My question is, and I genuinely don't know the answer to this, PIs are immediately appealable. Class action certification decisions are immediately appealable. But does a mistaken analysis of a prospective class give some extra weight to a PI appeal, and can that even be raised in the context of a PI appeal?
So,
Go ahead.
oh, sure. Dean McAllister noted that there's an avenue for appeal, but it's a discretionary appeal under 23F.
Mm-hmm.
And so I think even a TRO where there's a clearly erroneous class certification would open up to that appeal now and open up at least the jurisdiction. But the appeals court has the opportunity to just simply deny jurisdiction or just deny the appeal, deny taking jurisdiction over the appeal. And that would leave it difficult for the Supreme Court to review. Though who knows, there would still be the emergency docket there. And that's up, which is defined by what the Supreme Court is willing to review. So.
But don't you think the grant of a preliminary injunction that's based on the finding that the putative class is likely to be certified or something like that, that would be reviewable in the CI appeal?
Then you have, but then that's just straightforward 1292.
Right.
But there would be multiple routes to appeal, discretionary and mandatory, and the Supreme Court could review the denial of review on the 23F appeal as well, through the emergency docket, of course. But I don't think any way avoids an emergency docket if that's where you want to go.
Thank you.
Okay. Next question. Yeah. Oh, I'm sorry. There's a second mic. I didn't realize that. Oh, next question over here then.
Nicholas Nelson from Minnesota. This is not the first time in history that we've had a sentiment that maybe certain kinds of cases are just too big or too important for one judge. Why not bring back 3-judge district courts? And if we did, would that have to involve Congress?
Yes.
I think I said.
Are you saying yes to both, but why not? You're saying yes, bring them back, and it would require Congress?
Yes. I mean, I think I said bring back 3-judge district courts and do it with a centralized court that uses them as 3-judge district courts. You could just bring them back normally for certain kinds of challenges to government policy or state policy too.
Right.
That still wouldn't solve the forum shopping problem.
Right.
You could bring back, Congress can create 3-judge courts, but unless it is a centralized court, you would still have the forum shopping problem. Plaintiffs are going to be just as happy with a 3-judge court in the District of Massachusetts or the Northern District of California as they would with a random draw.
Although it lessens it a little bit, I think. You don't get the same sort of single judge division problems that you can see in other places. So I think it's preferable to a single judge, and I think. I'm very sympathetic to the sentiment that some cases are just too big for a single district court judge, but Congress would have to fix this, and a lot of these are problems that Congress could fix.
I'll just mention this has been proposed. There have been bills introduced to set up these 3-judge panels. I don't think since CASA or in this Congress, but certainly in previous Congresses, including the last.
Yes, sir.
Aaron Bernard. My question is, could the Supreme Court solve this problem by reviving the irreparable injury rule, which is we've lived in the world of Winter and Niken for the last 20 years when we've seen this explosion of these non-party injunctions, but there'll always be an emergency docket. There'll always be the death docket, and there'll always be true emergencies. They're knocking down the building tomorrow. So would a revival of the irreparable injury rule also do this, and the Supreme Court could do that?
In terms of granting injunctions by the district court, or in terms
so right now you go to the district court and you say, my First Amendment freedoms for one moment were stopped. Therefore, I've suffered an irreparable injury, and that fills me out, and I can get a PI under Winter. But historically, if you actually applied something like Grupo Mexicano to this idea,
that's not exactly right, though, is it? I mean, you've got to have a showing of imminent likelihood that you're going to be injured again. It's not just the fact that you were injured yesterday that's going to entitle you to that kind of relief.
But that's the kind of relief that's being granted. Perhaps some courts would not issue that or reason along.
I mean, that's really a standing issue, isn't it?
Well, it's also a question of remedy. What is a properly, if you ask the Grupo Mexicano question and you say, is this something that would be remedied at Chancery at 1789? Is this in one of those classes of injuries? On one hand, you have death penalty or something truly irreparable. There's historically a stronger irreparable injury rule.
Maybe. If you make it harder to give injunctions, then maybe there will be less pressure on the shadow docket. Then the question would be, well, what are the alternatives? It's not going to solve the APA problem because you don't need irreparable injury to Well, I don't know. I don't think you do. Admin people correct me. I don't think you do if you need to get vacatur, so it wouldn't solve that problem. The other thing is you still have the forum shopping problem. So who's applying the irreparable injury rule? Well, it's still the District of Maryland and the Northern District of Texas. And they said, oh, we found it, even under the higher, stricter standard. Just like the courts have resolved all the CASA follow-ons as meeting all the Rule 23 requirements.
Thank you.
Okay. Next question.
Hi, my name is David Latt. I have a Substack newsletter, Original Jurisdiction. I'm curious, certainly my quality of life as a journalist has been dramatically reduced during the Trump administration because there's so much news to cover. But on the bright side, to quote the late Robert Bork, it has been for Civ Pro and admin law nerds an intellectual feast. So I want to focus on a dish that the panel hasn't really focused on, the Administrative Procedure Act question, and this issue of whether or not a district judge can set aside administrative action in a way that basically amounts to another universal injunction. So I guess my question, maybe for the academics on the panel, but I welcome anyone's thoughts, is, sorry, it's a two-parter. One, what's your normative view on this? Does the APA authorize that action? Two, what's your predictive view? What will the justices do if this case comes up?
So 706 passed by Congress. So Congress has authorized the courts to do this, says that the court can hold illegal and set aside the challenged regulation. And there's certainly academic discussion over that. As a small brain myself, without the big brain academic credentials, set aside to me means set aside. Mm-hmm. But there are certainly academics that suggested that it has a narrower meaning than that, and maybe they're right about that. But so many of the justices come from the D.C. Circuit, where they were very used to setting aside regulations on a universal basis without anybody questioning it. I think there's going to be a psychological barrier to learn that they've been doing it wrong all this time.
Anyone else?
I will violate your panel rule and defer to Professor Lawson, who I see as a question. He probably knows the answer to this.
Yeah, he's not a panelist. He's got a
I know. That's why I say I was violating your rule, Judge.
Professor Lawson.
Hi, Gary Lawson, University of Florida, Levin College of Law. If 706 says that, it's unconstitutional, and that's essentially my question. Is in a way somewhat different from what Mr. Spalding was suggesting. Is the Supreme Court actually the source of the problem here? Because CASA was a statutory case. The court did not say that universal relief violates Article 3. Should it have? I mean, if courts exist to resolve disputes, well, obviously they can't award damages against non-parties. Why can they grant criminally enforceable injunctions against non-parties or for actions against non-parties? On the other hand, if courts exist to declare the law and keep other departments in check, this kind of relief starts to look more plausible. Doesn't the court see itself primarily as a law declarer and institution checker rather than a court? So is the court the source of the problem because it treats itself and therefore gives the signal to the other judges that, you don't exist to resolve disputes, you exist to keep everybody else in line?
I don't know that the formal structure of judicial review in the United States actually maintains the kind of case and controversy requirement that you would want. So the class action rules and even the associational standing rules claim to be consistent with the Article 3 framework, where they're only resolving cases or controversies. And it's a case or controversy with respect to members of the class. And so just as a practical matter, I'm not sure that it matters very much whether or not they said that they can't do it under Article 3 or not.
This makes me think, if I'm hearing your question right, Professor Lawson, it's the real problem is sort of of judicial supremacy, not necessarily any kind of interpretive problem with the Judiciary Act. And I guess I'm hesitating to think of a scenario where, and so maybe this is the answer to your question that you may be right, but a scenario where in the context of a narrow dispute between two parties, that complete relief would require a universal injunction, right? Or any kind of universal relief that extends beyond the two parties. And I'm hesitating to think of something on the fly that would require that outside of like a class action context, right? Which is why then I'm back to the class action bucket as the sort of preferred, because at least in theory now we have not just two parties or a limited set of parties who are before the court. So if we're limited to a traditional dispute that doesn't have a class action mechanism, then maybe the answer is that does exceed Article 3 judicial power.
A friend gave me this example, which is that tariffs have to be uniformly declared. So you couldn't give just relief to one party on a tariff. You have to strike them up or down.
Fair enough. Yeah.
Next question.
Devin Watkins. If we bring back 3-judge original jurisdiction panels for these kind of nationwide preliminary relief, should we also revive mandatory Supreme Court jurisdiction in these cases so that if a majority of that 3-judge panel finds that nationwide relief is appropriate, we have direct review by the Supreme Court right away in all cases, thereby extinguishing any benefit bringing in a specific jurisdiction?
I like that proposal.
Well, I mean, we still have mandatory appeals from 3-judge courts that do exist. And what does the court do with them? It treats them like certiorari petitions. Right. Yes. It sometimes denies them summarily or affirms summarily. So I don't know that it would make a difference, but sure, we could say that it has to be mandatory.
I like the idea because it means less work for the Court of Appeals. Yes, sir.
Great. Professor Elon Werman at the University of Minnesota. The based version of my question is, should we have the Supreme Court reverse Ex parte Young and Abbott Labs v. Gardner? In other words, isn't the real problem that these cases have been misinterpreted to create this free-floating cause of action for a pre-enforcement injunction? If this weren't in a pre-enforcement injunction posture, we wouldn't have all of these questions about universal injunctions and state standing and so on. So how have the great citizenship decisions in our country's history actually been decided? Dred Scott actually had to sue in court for a question to emerge as to his citizenship status under Article 3. Ed Bates, President Lincoln had to decide who were citizens of the United States for purposes of giving coasting licenses and passports. Wonky Mark was denied entry at a port of entry. So why is the default, so to speak, that, oh, of course you can get a pre-enforcement injunction. Why don't we wait until somebody actually is denied some tangible benefit of citizenship to decide their citizenship status? And if that's true, all this conversation is solved, no?
I can ramble about this.
Yeah,
you know the arguments for why there's pre-enforcement review, which is that people don't want to have to wait until they're getting sued by the government to raise the argument. So like your solution might solve the problem, but at what cost? You have to like wait until you're getting prosecuted before you're allowed to determine what your legal rights are. And so there's been a shift in the last, 55 years towards more pre-enforcement review. Ex parte Young is a much earlier version of it, but then you've got like all the APA cases that permit earlier challenges to rules. And the reason is because like maybe you think it's good to settle legal rights earlier rather than later before people have to bet the farm or whatever line the court uses there. So you know the answer to your question.
No, I agree with Garrett. I mean, I think the cost of maybe Ex parte Young is been used too broadly, too freely, but I think the cost of doing away with any kind of pre-enforcement review is too great.
Any other thoughts? Okay.
The really based version of the Professor Warman question is, should we have a Supreme Court?
Well, the Constitution did create it, so that's going to be a bigger lift.
Well, but Congress can shift the jurisdiction also, which is true. You occasionally see threats of.
No one else is at a microphone to ask any question, and we're near the end of our time. I would point out that our next program is a networking break, a networking break panel. After the next panel, breakout panel, will start at 3:45. But before we leave, please show your appreciation to our great panelists.